Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. My name is David Walker and I'm a private equity partner in the London office of Latham and Watkins. In this episode, we're going to discuss the growing use of share-based incentive schemes coming from the US and how PE sponsors may look towards these schemes to reward their non-managerial staff amid a period of economic uncertainty. In other words, how can share ownership opportunities help portfolio companies of private equity funds retain their employees? So to answer that and discuss this issue more broadly, I'm delighted to be joined by my partner, Kendall Burnett. Kendall's practice focuses on all aspects of employment, remuneration and incentive matters for public and private companies. And she serves as a member of the Employment Lawyers Association and also the Share Plan Lawyers Group. So who better to discuss these topics with than Kendall? Welcome to the podcast, Kendall.
Thank you, David. A pleasure to be here.
So to kick off the conversation, I think, and to set the scene, we all know that private equity MO is to acquire businesses and reward a management team, typically with share-based incentives. But what we're seeing is an expansion of that to attempt to reward a much broader range of employees down to people of a pretty junior standing in the company. And the reason for this trend is quite complex, but I was interested to see that recently I heard that over 21% of working age adults are not working and are not looking for work. So I think it's quite easy to understand why it is important for private equity-backed companies to seek to attract and retain the best quality people. Kendall, perhaps we kick off by you telling us what moves you've been seeing in this space and what private equity funds are up to.
Absolutely, David. So recently we've seen some pretty impressive payouts in the US for shop floor employees, which has received very favourable press coverage. There's been favourable returns for PE houses, which underline the positive results and publicity that can be achieved from a very well-structured incentive plan. Amid those economic stressors that you mentioned, David, we are seeing that more sponsors are looking to explore these share-based incentive schemes to reward employees.
And how do you think those sorts of incentive schemes would work under the UK regulatory framework?
Sure. So employee incentive schemes, they do offer many benefits, but structuring a scheme in the UK does require quite careful planning. The UK government has tried lots of different approaches to try and encourage employee share ownership. It's not new, particularly through various tax-efficient types of schemes like company share option plans and EMI plans. More recently, the UK government has allowed tax breaks for business owners who divest their businesses to employees through employer share ownership trusts. However, these schemes are generally not suitable for PE portfolio companies and are difficult to administer, primarily because of the strict qualifying criteria that there is for UK tax advantage plans. And also in the UK, there are certain restrictions on UK companies' ability to buy back and recycle their own shares.
Right. So, but I mean, if PE sponsors want to incentivize non-management staff, why don't they just use the same method they've been using for years when they reward managers? So just issue all of the employees with shares?
Yeah, it's a really good question. One of the big issues that we often find is that non-managerial employees are unable to afford shares at market value and to be able to purchase those shares. And what we do often find alongside typical PE management incentive structures is whereby loan arrangements are put in place for employees. Now, there are certain UK tax and regulatory issues that have to be navigated when using loans to employees, which can make the arrangement a bit more complex. Also, as well, just to bear in mind that having a large shareholder base can sometimes be quite administratively burdensome, particularly if there are a large number of levers that needs to be processed.
Yes, I see that. And I suppose there also potentially be issues when it comes to an exit to get all of the shareholders to sell at the same time. So I can see why shares may be cumbersome. Why don't you tell us a little bit about options and whether those are less challenging?
Sure, absolutely. Share options can be a cheaper and simpler way to implement a share ownership structure than issuing shares themselves to employees. Essentially, a share option is just a contractual right to receive a share at a future point in time upon payment of an agreed exercise price. Share options can be granted as exercisable only at an exit, which means that you don't have to deal with the ongoing administration of having employees exercising their options as they vest. Typically, options will be subject to automatic lapse provisions, which means that if an employee is to leave, then they lose their options. The benefit of delaying the exercise of the options until an exit is really it means that employees aren't required to invest their own funds to acquire their shares because the exercise price can simply be netted off their exit proceeds. The one thing about share options that I should mention is that they aren't as tax efficient as an employee holding shares and those shares being subject to capital gains tax. This is really because an option gain will be subject to income tax and employee and employer's NICs in the same way that a cash bonus will be taxable. They are definitely a lot easier to administer than a traditional PE style MIP, but of course they don't have the same tax efficiencies as managers holding shares and those shares being subject to capital gains tax. The other point just to bear in mind that in some jurisdictions, like in the US, the additional tax analysis is often required there because options typically need to be granted with an exercise price that's equal to the market value of the underlying share at the date of grant.
Okay, I see. So private equity sponsors could give the non-management employees shares, which are tax efficient, but there are regulatory hurdles to overcome and administrative costs and potential difficulties around levers and exit. Or on the other hand, they could give them options which are subject to less regulatory oversight, but require more tax analysis, are less tax efficient, in fact, in the UK, and sound like they're potentially quite complicated. Is there any other way of structuring, any middle ground between share-based incentives and option arrangements?
Yes, we are increasingly seeing phantom share awards being used to incentivize employees. These are typically a right to receive a cash payment equal in value to the growth of a particular class of share, or sometimes a fraction of a share, between the date of grant and an exit. Unlike a share option, a phantom award does not confer a right to receive a share. The individual will never become a shareholder and be on the register of members, and payment for a phantom award is always paid in cash. Often, phantom awards significantly simplify the securities law analysis in overseas jurisdictions. So it is quite easy to implement and roll out a phantom plan across a number of different jurisdictions on a global basis. We have seen a number of phantom plans being adopted recently on transactions, and they have been hugely successful. With a phantom award, they can present the same tax issues as options and cash bonuses because ultimately a phantom award is taxed in the same way as a cash bonus, whereby the taxable amount will be subject to income tax and employee and employers' national insurance contributions in the UK. The other structure to bear in mind that we also see sitting alongside these types of employee share schemes and typical PE MIPs is employee benefit trusts. They can work very well alongside employee incentive schemes, and they can either be used as a vehicle to acquire and warehouse management incentive plan shares from leavers and recycle those shares from new joiners. And also, with the right planning in place, an EBT on an exit, to the extent it's holding any surplus assets, then those assets can often be used to fund payments under a phantom plan or otherwise fund cash bonus or transaction bonuses that are going to be paid out at exit.
I think they're clearly an interesting way of incentivizing non-management staff, and this whole area is increasingly going to be explored by private equity sponsors and is clearly complex. But I think the advice to our listeners is to come to a good law firm to get the best advice, and we will even come up with a really good name for the plan to help you incentivize your team. So thank you very much for your insights, Kendall, which as ever incredibly valuable, and really appreciate your time today.
Thank you, David. Pleasure to be here.
And thanks to all our listeners for connecting on this episode. You can subscribe and listen to new and indeed archived episodes of Latham's podcast on lw.com, Apple Podcasts, Google Podcasts, Spotify, or indeed wherever else you get your podcasts. And if you'd like more information about the topics in this podcast, please email us from the links located in the show description, and Kendall or I will get back to you. Thanks very much. Goodbye.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.